Hello everyone, welcome to the 80 Literary and Jury Charge. I'm going to start off with a paragraph that focuses on different phrases. So you're going to hear the following phrases. From time to time, which is FRIMT. Left hand, which is initial L, final ND. So initial L, final ND. If it's left hand side, it would be initial L, final NDZ. On or about, OERB. Did he or he have, or you can phrase the whole thing, DEV. To the, as much as, initial S, final FPS. Okay, let's see here. We've got cause of the accident, KAUBGS. Cause of the accident, KAUBGS. And you're also going to hear workers' compensation coverage. So there's obviously no brief for that, but or one that I know of, but you are going to hear that. Workers' compensation coverage. You're going to hear previous, which is PR long EV. Employment, PLOI final MT. All right, here is your paragraph. On or about July 29, Bill Smith will enter the hospital. He injured his left hand quite severely in an accident. As to the cause of the accident, I know as much as you do about it. Please let me know from time to time how he is doing. Did he have workers' compensation coverage at his previous place of employment? All right. I have some literary for you. Let me give you a word list. You're going to hear issuance, institution, credit, administration, partner, forfeited, capital, competition, facilities, varied, universal, financing, merger, management, research. And the brief for finance is initial F, final N. So financing, you're just throwing in the G. Okay. You're also going to hear small business owners, small business administration. All right. So I will read, this is literary, so I'm going to read this at 60. Okay. Here we go. Most of the problems that exist in large businesses also exist in smaller businesses, but to a different extent. All businesses are faced with universal problems, which include financing, management, competition, and research. Whether large or small, businesses all have a need for capital to get started and to expand. Sources of capital are widely varied and can range from a friend or relative to a large financial institution. Establishing a credit rating is another difficult process. Small business owners frequently borrow from friends or relatives, savings, or the Small Business Administration for loans. Accepting a partner or partners is another way of obtaining capital, although some degree of control in the operation is usually forfeited at this time. All right, moving into jury charge. The subject here is punitive damages. So I write that out. I don't have a brief for it, but you are going to hear that. Punitive damages. You're also going to hear instructions. The brief for that is STRUBGS. And then, you're going to have to come back for final Z if it's plural. Testimony, initial T, final M. Let's see, evidence, EFD. Defendant, DEFT. Plaintiff, PLF. Circumstance, SIRK. Ladies and gentlemen of the jury, LJS. And you're going to hear whether or not. You can phrase that. WHRORN. WHRORN. All right, I'm going to read this at 80. Here we go. Ladies and gentlemen of the jury, if you find that the plaintiff was unlawfully evicted and obliged to leave the premises without notice by reason of the wrongful acts of the defendant, then you may consider whether or not, under all the circumstances, the plaintiff is entitled to recover what are known as punitive damages. Such damages are by way of punishment, that is, to punish the wrongdoer for his wrongful and unlawful acts and deter him from committing like offenses in the future. You may take all the facts and circumstances into consideration and then award such an amount for punitive damages as you feel would be fair and just under the circumstances. Punitive damages are allowed only when one does an act wrongfully and maliciously in the contemplation of the law, where one interferes with the rights of another knowingly and purposely, if at the same time he knows it is wrong and unlawful, then it is malicious. Punitive damages should not be excessive and should be reasonable. They should be fitted to all the facts and circumstances in the case. It rests entirely with you whether or not you should award any such damages. If you do, they should be fair and reasonable. The jury are the sole judges of the facts in the case. The credibility of the witnesses and the weight to be given to their testimony in anything that the court may have said throughout the trial, or anything that the court may say in the instructions. The court has not intended and does not now intend to express any opinion upon the facts of the case, upon the credibility of the witnesses, or the weight to be given to their testimony. Furthermore, the court instructs the jury that you have a right to consider all the evidence in the light of your own observation and experience in the affairs of life. All right. Moving right into our next drill, our next selection. I have some congressional record. The subject is family rental tax. Actually, you know what? That is not what I wanted to do. I'm sorry. I marked the wrong page. I want to give you Latin and French words. So sorry about that. I put my little sticky on the wrong one. I've already read this congressional record. All right, so I am going to be reading Latin and French words along with the paragraph that it comes with, okay? You're going to hear carte blanche, okay? Quantum meruit, ultra vires, intra vires. Okay, so after class, I encourage you to go in and add those words to your dictionary. Okay, so let me say them again. Carte blanche, quantum meruit, ultra vires, intra vires. All right, here we go. Here is your paragraph. I'm going to read this at 60. Carte blanche means unlimited authority. Generally, carte blanche gives another person the power to fill in a blank instrument as he chooses. Quantum meruit literally translates as much as one deserves. Using the theory of quantum meruit, one may recover a reasonable value for any work or service performed. An act or contract which is not within the powers of a corporation is an ultra vires act. Ultra vires acts are generally outside the scope of authority conferred by law. The opposite of ultra vires is intra vires. A matter that is intra vires is considered within the legal powers, control, or authority of an individual or an institution. All right. I have an article here on the general introduction to the legal system. Okay. And I'm just dating this. All right. Here we go. Ready? I will read this at 80. Sources of American law. Modern American jurisprudence finds its origins in the small towns and villages of England. There, judges resolved disputes by making decisions that were based on custom, common sense, and fairness. These decisions, although at first not recorded, became part of an ancient tradition known as the common law. As the common law developed, so did the principle of stare decisis, or precedent. When a court made a decision based upon the facts of the case before it, that decision provided guidance for other courts faced with similar sets of facts. Gradually, the courts developed the policy that a decision of a court was binding on that court and on other courts of equal or lower rank when the same or a similar issue arose in the future. The reason for this policy was simple. People functioning in a society need to know the rules so they could conduct themselves accordingly. They need to know that a particular decision was the law, would remain the law, and would not be changed the next time a court was faced with the same issue. In England, although the common law was the primary source of legal rules and principles, statutes gradually played an increasingly important role. A statute is an act of a legislative body that may be a prohibition, a command, or a declaration. The meaning of the various statutes was not always clear. However, nor was it always obvious that a statute was applicable to a particular set of facts. Thus, courts assumed the responsibility of construing statutes and applying them to various fact situations. In the United States today, the common law, statutory law, and the principle of stare decisis form the backbone of our legal system. the courts of our nation in resolving disputes or interpreting statutes are guided by the decisions that other courts have made in the past when faced with the same or similar issues. These decisions, unlike those of the ancient English courts, are recorded and presented in law books so that lawyers, legal scholars, and judges may refer to them and study them whenever they need guidance. All right, so that concludes our literary and jury charge for the 80 speed class.